Hi, this is Danny Womack with City Hope, and today we're going to be talking about restraining orders and some of the considerations and the process involved in getting a restraining order. Your client may very well be eligible for a restraining order, and basically a restraining order, also called a protective order, is a court order saying that somebody is protected from being physically or sexually abused, threatened, stalked, or harassed, sometimes even contacted. And sometimes even the restrained party would be prevented from coming within a certain distance of the protected party. And before we jump into all of the things to consider in the actual process, I've often heard it said that what good does it do because it's just a piece of paper? And can a piece of paper really protect somebody? And while I understand that obviously no, if somebody's come and is determined to be violent, that piece of paper is not going to provide any physical protection. However, it's important that our clients understand that that piece of paper is a court order, which gives the authorities the ability to proceed differently in a situation where that court order is being violated than they would be able to proceed absent that court order. Let me give you an example. If authorities respond to a domestic violence situation and there's obviously abuse happening or alleged abuse, the authorities need to stop and look and try to determine if abuse has happened, if there's been a violation of laws, and if so, who the primary aggressor is. And in California, they have to arrest whoever that primary aggressor is. But there's a determination that has to take place. When you have a restraining order and it's a protective order and that person is not allowed to come within a certain distance of the protected party, the mere fact that that person has violated that order is a crime, and it can elicit new charges against that person. Which means when police arrive on scene, they don't have to determine who the primary aggressor is. Immediately, the restrained party has violated the law by violating that protected order and that court order and can be removed and arrested. I'll also tell you from being a chaplain and working with law enforcement that when an officer is dispatched to a 911 call, if there's a protective order in place that is being violated, most of the time that information is given to that officer, and that heightens the response of that officer because he knows that there's already been an issue and a judge has already said that the restrained party cannot be at that particular location or in contact with that protected party. And so it heightens the response of law enforcement, and it heightens what they can do when they arrive on scene. So it's important to let your clients know in the consideration of whether they go after a restraining order or a protective order that it does change what law enforcement is able to do. And on that regard, it can provide long-term some additional protection from your client, for your client. So make sure you go over that with your client as they're trying to make the determination on whether they're going to go after a restraining order. So a restraining order can do a couple of things like we've talked about. It can protect the protected party from the restrained party, saying that the restrained party cannot stalk or cannot contact or cannot abuse the protected party. It can prevent harassment. It can be a no contact order, which means that phone calls need to stop, which means that they can have no direct communication between each other. If the restrained party is continually texting the protected party, it can create a situation where that has to stop or it's in violation of the order. It can keep people a certain distance away, which means that if the protected party is out at a restaurant and the restrained person just happens to come into that restaurant, the protected party can remain protected and the restrained party will have to leave. So it is helpful apart from just a particular address. It allows that the protected party to be to be in the center of a safe space and a safe distance from which the restrained party cannot come. And children can often be listed on that protective order as well. So if it's the victim of the domestic violence, but the children have witnessed it or the children are involved as well, you can petition for those children to be named and the locations that the children frequent, whether it's the school or the daycare provider, those types of things. The protected party can ask for their place of employment to be listed on that protective order as well, so that they're not being harassed at work and creating issues at work. You can also, as you are petitioning the court for a protective order, restraining order, you can also ask for a kick-out order, a residence exclusion, which means if the restrained party and the protected party have been cohabitating or they live at the same place, that you can ask the judge to determine that the restrained party cannot live there while all of this gets figured out, thereby allowing the protective party and or perhaps the children to be able to stay in that home. So there's a lot that can be done with these orders. And it's important to understand the process and for your client to understand the process in obtaining a protective order. There's a couple of steps that are involved. The first one is that you have to submit a request and submit the proper court documents. Most of the time, these court documents are listed even online and can be downloaded and completed online. Or downloaded and printed and then be able to be completed. So a couple of thoughts with that. You want to ensure that your client knows that if they download it online, if the hopefully restrained party is there or has access to that computer, we want to make sure we clear out search histories or have somebody else download it for them. We wouldn't want this to be something that the client is trying to do kind of on the down low without the aggressor recognizing it, and they go and they find that all of this has popped up on the computer. That could be a dangerous situation. We want to avoid that. So the protected party would get the paperwork and would begin to complete the paperwork. And that's something that as a volunteer you can help them do. There are also some fantastic community organizations that we can put them in contact with that will help them fill out the paperwork as well as prepare them for the potential court hearing that could come as a result. As the paperwork is filled out, we want to encourage our client to be as complete and thorough as possible to make sure that if they've been hit 17 times, that information is on there, that details of each time is listed on there. We can always add additional paperwork if necessary. If there's pictures, if there's copies of the text messages, if this person has been texting threats or texting about violence or repeatedly texting time and time and time again, all of that information can be included in the paperwork, and it's really important to do so because chances are the court is going to consider whether they give the client a temporary restraining order completely without even a hearing, which means based upon what you submit, what the client submits in that packet, the initial determination on if there's going to be a temporary order made is going to be made. And so we want to make sure it's absolutely as complete and thorough as possible. And then your client will go and submit this information to the court. Oftentimes courthouses have a clinic where they can go and have somebody review just to make sure that the information is all nice and complete and the forms are filled out correctly. And then it's going to go to the clerk, and the judge may look at all of that paperwork that day and determine if a temporary restraining order is going to be granted or not. And that's done without even hearing from the other person. And so your I's need to be dotted and your T's need to be crossed. If at that time the judge decides that they're going to give a temporary restraining order, it's done ex parte, they haven't heard from the other side, so it's a short-term thing, typically 2 to 3 weeks, while they wait for a full hearing to happen, which would include the potentially restrained party as well. So if the judge issues a temporary restraining order, they're going to go ahead and give the client back a whole bunch of paperwork, including the temporary orders. It will also have the actual date of the hearing, the full hearing. And that has to be served on the restrained party, which means you need to encourage your client to look at if there is somebody who can facilitate service of process for them. Often our law enforcement is willing to do it. Sometimes there's a fee included with that, sometimes not, so it is an option. Service of process can be made by a third party who's willing to serve the restrained party. It can be made via mail as well at times. We just have to make sure that the person's over 18 and that it's not the client that's doing the service of process. Whoever does the service of process has a form that they'll have to complete, and that gets sent back into the court so that the judge knows that the restrained party has been notified, they've received the notification, and knows when the next court date is so that they can plan on attending that court date if they'd like to do that. So service of process becomes very important. And sometimes it's difficult to serve the person. If you've been cohabitating and now you can't find this person because they're not living there anymore, you don't have a valid address, or if they've taken off and they're on the run now, that can be a challenging process. And so if the client wasn't able to effectuate service of process, we still absolutely want to encourage our client to go to court at the scheduled hearing date, because at that point the judge can extend the restraining order while they look for the restrained party. And so we do not want that to lapse in the meantime while we're trying to effectuate service of process. So if your client was able to secure service of process, then when they go to court on the actual hearing date, that's when the judge will hear from both sides and will be able to determine if the judge is going to impose a more permanent long-term restraining order. And those are often either 3 years or 5 years, where the terms and conditions of that restraining order remain in full force and effect during that time. If you're granted the restraining order, whether it's a temporary one or the more permanent one for 3 or 5 years, you want to make sure that you have a copy of that. You want to make sure that law enforcement knows that there's a restraining order. You can go to your local law enforcement and they can enter it into the system to ensure that it comes up and they know that this party is restrained from certain locations, or that you're the protected party in a restraining order. You also want to make sure you keep a copy handy in case for some reason law enforcement isn't aware. We encourage our clients to keep one in their purse or their wallets, in their car, at their desk, in their place of employment. If we recommend that the schools have copies if children are named, or even if it's just a place that you frequent, gyms, those types of things, to make sure that there's copies available wherever this person might show up. Because again, that protective order gives law enforcement additional abilities to be able to respond to the situation in different ways. And if it's not there, and since it is, you want to make sure, your client wants to make sure that law enforcement knows that that restraining order is there and in effect. So if the abuser or if the restrained party violates that restraining order, then you want to make sure that you call the authorities. You want to have your client note on a log what the violation was, what happens, if there's evidence of the violation. All of that we want to keep as evidence and part of the file that's kept, and your client wants to keep that so that they can be able to turn that over to the proper authorities as well. So what we're going to do now is there's going to be a video that talks about what the steps of obtaining the restraining order looks like, and some additional considerations for each step in each phase of getting the restraining order. So for those of you going through this class as part of the City Hope training, what I'd like you to do is I'd like you to watch it, and I'd like you to think about the considerations. What type of information is needed at each stage? What needs to be done? How do we prep our clients? How do we have some of these conversations? All the thoughts that you would think if this is a real call where you need to be able to help a client make the determination if if they're going to get a restraining order or not, and how they go about the restraining order. The video shows the steps, and I want you to fill in how you would actually utilize that as you're working with a client.
Well, this is Dr. Stan DeKoven. I hope you've enjoyed our course and the courses on domestic violence. Just want to share some thoughts here. We want to especially thank Danny Womack for the incredible expertise that she's shown in her teaching on domestic violence intervention. She's given you an assignment in her video. So we want you to complete that assignment and hold it until the end of the course. Once you've completed the worksheets in Unit 3 and Unit 4, you want to email them to yours truly. That's sdekoven, my last name, DEKOVEN, @vision.edu. Or you can snail mail it to me at Dr. Stan DeKoven, P.O. Box 1680, Ramona, California 92065. Attention, DV certification, and I'll make sure your material gets graded and of course get your feedback and all of that. So again, we want to thank Danny and the team at City Hope Ministries, and also all of you students. We're trusting that this has been a valuable experience for you.